Okay, this is the first of two chapters dealing with ethical issues in corrections. And this one is dealing with the nature of corrections. So one thing we want to think about is how rapidly the prison system has expanded, both in terms of the number of people incarcerated and the number of facilities. So in 1982, about 200,000 people were imprisoned, but that number triples between 82 and 99. There's over 600 state and 51 federal facilities open during that time, and the number of jail inmates triples. The number of adults on probation also triples, and the number of correctional staff more than doubles. So between 1980 and 2003, the imprisonment rate at the federal level increased 518%. So from about 11 inmates per 100,000 people to 68. That also then has a corresponding 595% increase in terms of funding, from about $970 million to $6.7 billion. So since 2000, we've got this dialogue on crime control, and it's really focusing on incarceration. And where does this come from? Well, first of all, there is an overall decline in crime, and it's resulted in a reduced focus on crime in terms of politics. The fiscal crisis that's affected states and resulted in plans to reduce prison costs and prison populations, and the failure of the war on drugs. So from the 40s to the 70s, the prison population is generally stable per year. And there's a theory of stability of punishment here, that society reaches a level of punishment with which it is comfortable, and then it adjusts its policies to maintain it. But in the 60s, we have a big increase in the crime rates. Mostly this is because we have an unprecedented number of young men. So wherever the population of young men is, will impact the imprisonment rate. We know that crime is a younger person's purview, and so the more young people we have, the higher crime rate we should have. There's also a heroin epidemic and a lot of social unrest in regards to the civil rights movement and Vietnam. Public demonstrations against both of these issues, or in regards to both of these issues, start being treated as crime as well. And during the 60s and 70s, we also have the feminist movement is beginning, which has got a focus on victims' rights and crimes against women, namely domestic violence and sexual assault. In 1964, Barry Goldwater made crime a signature issue in politics for the first time. In 67, we have the Safe Streets Act, and this enlarges the federal role in crime control. And so this results in higher rates of crime reporting. In 72, the prison and federal and state prisons populations about 196,000, and another 130,000 are held in jails. In 1973, the prison population begins to increase. At this point, New York has passed the Rockefeller drug laws, and these impose mandatory prison terms for drug offenses. In 1974, Martinson publishes his essay, Nothing Works. And this is often referred to as the nothing works doctrine. He's basically saying that nothing works to rehabilitate criminals. And so if nothing works to rehabilitate criminals, we should just be incarcerating them. This finding is later challenged at the time. In the late 70s, cocaine becomes a widely used drug, and states begin to pass mandatory laws in terms of incarceration for that. And in the 80s, we have crack cocaine come on the scene. It's much cheaper to buy than cocaine and becomes widely used. Ronald Reagan gets elected, partially on his tough on crime platform. We start looking at crime as having an individual pathology, and nobody's really looking at the role that society plays in that. The Reagan administration greatly expands the war on drugs. In 1982, Congress authorized $125 million to create 12 new regional drug task forces. And in 1984, the Sentencing Reform Act establishes a federal sentencing commission. So this has got heavy presumption of imprisonment, little regard for mitigating factors. And these were considered mandatory until 2005, when the Supreme Court ruled that they're advisory only. 1986, we start getting the Get Tough measures. In 1988, the Anti-Drug Abuse Act is passed. The goal is to be a drug-free America by 1995. And also, George Bush's election campaign for president uses the Willie Horton incident to give a focus of getting tough on crime. You should open these slides. Actually, let me see if I could play them within the recording.
Bush and Dukakis on crime. Bush supports the death penalty for first-degree murderers. Dukakis not only opposes the death penalty, he allowed first-degree murderers to have weekend passes from prison. One was Willie Horton, who murdered a boy in a robbery, stabbing him 19 times. Despite a life sentence, Horton received 10 weekend passes from prison. Horton fled, kidnapped a young couple, stabbing the man and repeatedly raping his girlfriend. Weekend prison passes. Dukakis on crime.
And so that really becomes the downfall for Dukakis. Dukakis loses the election. In 1988, the DOJ continued its policy of playing a leading role in campaigning for punitive crime control policies. In 1992, we get more mandatory minimums. In 1993, we get 3 strikes laws in Washington state. In 1994, we get the Violent Crime Control and Law Enforcement Act, which gives us a federal 3 strikes provision, $8 billion for prison construction, and truth in sentencing laws, which require federal inmates to serve 85% of their time before being eligible for parole. In 2000, George Bush is elected, and he has a punitive approach to crime. 2001 to 2005, the Attorney General overruled prosecutors who recommended non-capital prosecutions, and the U.S. Sentencing Commission orders a reduction of the downward departures. So downward departures are where someone departs from the sentencing guidelines and gives less time. In 2007, obviously this massive prison population is taking a toll financially, and states start looking for ways to reduce their prison population. 2010, we changed the crack cocaine ratio. So the ratio had been 100 to 1. You needed 500 grams of cocaine to get 5 years, and 5 grams of crack would get you 5 years, even though they're essentially the same drug. So there is still a disparity here, but it is now an 18 to 1 disparity. This results in a 2.1% decrease in the prison population. Initially, in 2013, the decline was only 0.6%. In 2013, about 1 in 35 adults is under some form of supervision, and 1 in 51 adults are on probation or parole. And by 2015, more than half of the states have carried out reforms that stabilize the incarceration rates. So prison overcrowding. This has obviously an adverse effect. There's mental and physical health issues, higher risk of suicide. Just think about how you feel when you're in a crowded room and you know you're not going to have to stay there long term. So in order then to control the population, we see more lockdowns, more use of solitary, and a decrease in treatment. This also leads then to an increase in recidivism, and we also don't really see much in terms of preparation for re-entry. By late 2011, half of states are operating prisons above their design capacity. So by 2012, they're operating at an average of 38 to 52% above capacity. In 2011, Coleman v. Plata upheld Brown v. Plata that overcrowding in California prisons violates the 8th Amendment's prohibition against cruel and unusual punishment. And so they order the prison population reduced to 137% of design capacity within 2 years. So that means they have to reduce their population by 40,000 prisoners. 1 week prior, California had signed the Public Safety Realignment Act. They basically want to transfer or divert prisoners from state prisons and the parole system to county jail and community sanctions. They had no oversight, no evaluation of their outcomes. And many counties began investigating a jail expansion, have not actually utilized the grants for community services. So they were given grant money, being the idea being, let's try to get these people into community corrections. And instead they were using it to expand their jails. About 21 counties plan to build more than 10,000 new jail beds, and the state planned to spend an additional $500 billion on new jail construction. So basically all it did was take that state prison system and move it to the county level. So the criminal justice system is looking for new ways then to recoup those costs of large prison populations. And this has resulted in basically people being in prison for debt. And so this has been through civil contempt proceedings. So you owe the court money, and instead they proceed against you civilly and you end up being incarcerated. One thing to think about, though, is how are you ever going to pay that debt back if you're incarcerated, right? Because you're not able to obviously work to pay that. And in the meantime, they're going to accrue interest and surcharges. By 2004, more than 2/3 of incarcerated offenders had to pay fees and fines. And they owe an average of about $11,000 over their lifetime. So what happens is county clerks can apply to a judge to issue an arrest warrant for legal debtors. Even though we got rid of debtors' prisons, years ago. Okay, we also want to think about maximum prison. So the number of inmates in supermax prisons is estimated to be between 25 and 80,000. This is an attempt to make and maintain total or near total social control. So, Jones, L., and others versus Burge and Litcher from 2001 highlighted some aspects of Wisconsin's supermax. There was very little face-to-face contact with staff, very little light access. Cells were illuminated 23 hours a day. Inmates had to sleep in a way that the prison officers could see their faces. There's no air conditioning, solid cell doors, and a lack of windows means it's often 90 degrees in the cell, within their cells. No face-to-face visits except with lawyers. 1 6-minute phone call per month. We know that this is, akin to solitary, and we know that solitary can cause severe psychiatric issues. We've had information for, probably over 100 years that this leads to insanity and high numbers of suicide attempts. So the suit then alleged that prisoners are obsessed with suicidal thinking, smearing feces, swallowing metal objects, cutting off their flesh, and attempting to hang themselves. There was also a daily use of excessive force and a lot of self-harm, because basically that's the inmate's main outlet for expressing anger and aggression. So supermax were supposed to be used to house the worst of the worst, but there's no empirical evidence that supports that idea that it provides better safety. Now, part of the problem here is that there isn't a lot of research on this because it's very difficult to gain access to this data in these facilities. In California, prison violence has actually increased. So gangs have regrouped and found new leaders. So solitary confinement, as I just mentioned, is also obviously very detrimental. So by the 1830s, reports of sharp increases in mental disorders were coming out amongst inmates in solitary, including hallucinations and dementia. So we know that solitary confinement literally causes people to go insane. This might be manifested as anxiety, fatigue, confusion, paranoia, depression, hallucinations, headaches, uncontrollable trembling. So there's 3 waves then in how we're using solitary. In the 1850s, it's championed by moral and religious reformers who think that it's basically an opportunity to sit and repent, right? And that this will lead you to transform yourself from a criminal into a law-abiding citizen. In the 60s and 70s, behavioral scientists are talking about the power of psychology to re-socialize and rehabilitate criminals. And then beginning in the 80s, prison administrators are promoting and implementing notions of control that would be able to reduce risk to prison staff. So there's 3 main forms of segregation: punitive, protective, and administration. Punitive is when we're punishing a prisoner for bad behavior, so that's usually following a disciplinary issue and it's for a fixed period of time. Protective is when we use vulnerable prisoners and we keep them apart from the general population for their own protection, but essentially it's punishment as well. Administrative segregation is what we think of when we think about solitary. It's used to isolate prisoners that fall into certain categories: escapists, gang members, predators, and terrorists. So we know that the 8th Amendment prohibits cruel and unusual punishment, and the courts have found that physical conditions such as isolation, deprivation of hot water, soap, and clothing is considered unconstitutional. Permitting inmates to shower once every 5 days is acceptable. Without any additional deprivation, solitary confinement has not been held to be considered cruel and unusual punishment. So in 1995, in Madrid v. Gomez, the courts held that the meaning of the Eighth Amendment varies according to the test of evolving standards of decency. So prisoners are not wholly divested of their rights when they're incarcerated, and punishment that inflicts unnecessary or wanton pain or is grossly disproportionate to the severity of the crime amounts to deliberate indifference. But courts have been reluctant then to hold that any access to human social contact is permitted or that supermax confinement may cause mental illness. So about a third of inmates are held in medium security, about 10% in minimum security. Medium security has a lot of the same practices as maximum security, but they can work without constant supervision. Minimum security has a focus on vocational training and treatment, and it's generally nonviolent first-time offenders and white-collar offenders. So in 1977, Jacobs showed how the patterns of authority in prison have changed over time, and it's moved from rules about conduct being made on an ad hoc basis, with discipline exercised in an arbitrary and capricious manner, to a bureaucracy that depends on rules and regulations. And so in 1925, Statesville Prison opens, and basically people become employed as a result from political patronage. In the 30s, COs were working up to 16 hours a day and at least 12 hours. They were untrained, underpaid, and physically unfit, and disciplinary measures included solitary and stringing up. So stringing up is where an inmate stands handcuffed to the bars of a cell 8 hours a day for up to 15 days. So violence becomes pretty common here. Inmates were left idle, and the prison was overcrowded. From 36 to 61, the warden is Joe Reagan, and he exercises control over every detail. He demands absolute loyalty and ignores physical assaults committed by COs on inmates. He distrusted all outsiders and doesn't share any authority with his subordinates. He stressed inmates' entitlement to good food, clothing, and housing, and reformed the practice of stringing up. But instead, he required them to stand at attention in their cells for 8 hours a day. He rewarded inmates. Those with administrative positions could work at night and remain in their office and enjoy mobility around the facility. And he offered jobs to inmate leaders and tough prisoners as a reward. He used a silent system in the cafeteria while transitioning in lines. And officers were told not to fraternize with inmates. In the 60s, the court begins to define 4 categories of prisoners' rights. So one is access to the courts. One is the prohibition on cruel and unusual punishment. One looks at procedural protections. And then First Amendment freedoms of religion, assembly, and speech. So we see a marked change in the inmate population between 60 and 80. Prisons are holding more African Americans and young men with access to radical ideas. So this gives way then to sectional arrangements based on race in the old inmate code. This means, though, that there's a lot more uncertainty for guards. In 1970 to 75, the DOC takes a greater role. The gap between rules and working procedures was very evident, and rules were often ignored. New administrations begin to view inmates as redeemable, and we start to see the inmate grievance process being instituted. So what can we learn from Stateville? That discretion given to officers over their captives changed over time. It moved from an authoritarian regime relying on inmate informants and favors to a regime of intense supervision and extreme discipline. Administration became accountable to the courts, and we started to see radicalized prisoners practicing social activism. So as the nature of the population changes, so does the relationship between inmates and guards. Rules are attempted to replace officer discretion, but they're often ignored. So what's the subculture like in corrections? Is that subculture imported into institutions from the inmates, or does it come as a result of prisonization? One officer noted she entered the prison with sympathetic attitudes, and within a short time, her sympathies had been reversed. So the culture appears to be a product of an interaction of values that are brought into the prison socialization, deportation, and cultural evolution. So recruits are socialized to the guard subculture during their training. Their individual motivations for joining corrections may contribute to their socialization as well. And so Kauffman studied the motivations of guards and said that the jobs appealed to people who were unemployed, from communities where state jobs were considered significant benefits. More than half said financial considerations were at play. Some gave social work motivations, and about 20% wanted to be police officers and seemed attracted to the job by power and authority. So basically, it's a second choice career for many of them that allows them to sanction criminals. Kauffman found that most officers approved of an officer acting in a sympathetic manner towards inmates. 95% said an officer who broke up a fight between inmates should investigate the cause but do nothing if it was not serious. Just under half approved of not intervening if they observed fellow officers assaulting an inmate. He found that officers tended to adopt the values of the prison, and new recruits often found themselves depressed about the job. So they've been thrown into this hazardous, difficult job, and they're often isolated from their colleagues. So Kauffman talks about 5 types of guards: Pollyannas, white hats, hard asses, functionaries, and burnouts. So Pollyannas have sympathy for their inmates and care about coworkers, but are critical of the manner in which they interact with their inmates. White hats have a positive attitude towards inmates and a negative attitude towards their coworkers. Hard asses are the opposite of this. They have a negative attitude towards inmate and a positive attitude towards their fellow guards. Functionaries cope with prison by closing their minds to it. Think of it as a dead-end job. And burnouts have negative attitudes towards inmates and coworkers and are unable to cope with the outside world. So what's the role of power and authority? Hepburn talks about 2 different types of power in prison. Legitimate power, which comes from the position of the guard. Coercive, which is based on the inmate's perception that the guard has the ability to punish. Rewards, where guards are able to give rewards. Expert, which is derived from special skills or expertise. And referent, which results from gaining the respect and admiration of prisoners. So Sykes in 1958 found that officers saw themselves in a battle for compliance with inmates. Violence, sexual violence, and theft were commonplace, and the relationship between officers and inmates gave rise to a relationship of reciprocity between officers because officers could not remain distant from inmates or completely withdraw from them. But these officers are being evaluated based on their ability to control them. So they're always aware that riots and hostage-taking are possible causes of ruptures in the negotiation of power. So Sykes doesn't think that the use of rewards and punishment offers an adequate basis to enforce control. So think about things like good time, right? That's the proportion of your sentence that's deducted for good behavior. In indeterminate sentences, it's automatically deducted unless you violate disciplinary rules or commit a new offense. If it's automatically deducted, it limits its efficiency and efficacy as an actual incentive. So what are the dangers in giving awards or rewards? Inmates might try to corrupt guards. They might be used to blackmail guards. The rewards could cause disputes themselves. It's possible that valuable rewards such as drugs would engender more conflict. And officers engaging in the reward process run the risk of endangering their own guards. So for example, if they're bringing drugs into the prison. And finally, maybe the rewards just aren't even enough to induce compliance. So corruption is far more complex than what Sykes described. Inmates are better educated and more organized than before, and they move in groups that are involved in drugs and extortion. So Kauffman found most officers didn't write as many disciplinary reports except for major infractions. So basically, we see a lot of informal punishment. Locking inmates in cells, refraining from unlocking them during daily routines, flushing toilets back into cells, shutting off electricity, turning off hotware, withholding toilet paper, keeping back food, creating a wait for the phones, denying access to writing paper. So during the 60s and 70s, we see this increase in prison litigation, and these are some examples of how inmates begin to gain some power. So they start competing with officers for control over the inmate population. Unprovoked and spontaneous violence is obviously the thing most feared by guards, and drugs are considered to be the main cause of this. So when a police officer decides how to enforce laws, we call it discretion. When a guard decides how to enforce rules, it's seen as corruption of authority. This is a practice by guards of deliberately refraining from enforcing rules and regulations. Is this, however, a legitimate distinction? Guards perceive not enforcing rules as necessary to gain cooperation, and it can reflect the guard's relative powerlessness. So other forms of corruption of authority include loss of authority, where guards become too friendly, and handing over guard duties to inmates. So guards may become dependent on this, and this then in turn is going to weaken their authority and control. So then another issue we have today is private prisons. And the biggest private prison provider is CCA, Corrections Corporation of America. Half the states have no or few inmates in private prisons, but a third have about 10% or more. And these are most common in the South and Southwest. And we could see here that New Mexico has the most. Oh, geez, I don't know what NT is supposed to be. And the federal prison system as well. So these don't actually save us that much in cost. They tend to be more dangerous, provide less training, have higher inmate to staff ratios, and high staff turnover. One thing to really think about, though, ethically is, does it make sense to hand over a government right, which is the authority to punish people, to someone else? So legal punishment is that imposed and administered by an authority established by the legal system. We also want to think about, should these be run on a for-profit basis? Should we be profiting from the imprisonment of human beings? Is that really compatible with the purpose of imprisonment? Does the existence of private prisons then create a demand for imprisonment that creates greater levels of imprisonment? So these corporations may seek to influence policymakers, and they would then, in turn, of course, profit from a high rate of incarceration. How do they cope with the issue of deadly force? So this becomes an issue because it is not state-run. It also becomes an issue in terms of if an inmate assaults a staff member, it's no longer necessarily a crime. It's considered a civil issue. It's considered a tort. We also have an issue related to escape as well. So many states also disenfranchise inmates. They revoke their voting rights. Some do it while they're incarcerated, and some do it for lifetime. So this results in about 2 million white Americans becoming disenfranchised, and 1 in 4 black men are permanently disenfranchised in 5 states. So only 51.3, that should be million, of those eligible to vote did so in the 2000 elections. So we have a social contract argument here and a so-called electoral purity argument. So the social contract argument says felons rejected the rules of society, and so they shouldn't be allowed to participate in the electoral process. Electoral purity says only those worthy of voting should be allowed to vote. So about 8 in 10 Americans support voting rights for those who've completed their sentence, and about 2/3 support it for those on parole or probation. And that wraps up this first chapter on corrections.